Kindly let me know if I'm not audible to anyone. Okay, audible. I hope the screen is also visible to you. I have written IPC 1860, then G stands for general exceptions, and I have written consent. We'll relate it to rape as well. And we'll relate it to various other sections like section 87, then 88, and others. So guys, yesterday we discussed just a sec. I'll Yesterday we discussed about the defense of unsoundness. That was section 84, and we discussed it in quite detail, right? So none of you asked me that what will happen once the defense of section 84 is proved. What will happen? Like if section 84 defense is proved by the accused that yes, the person was of unsound mind at the time of doing the offense, hence the society should not consider it as an offense as the element of as one of the element of crime, that is mens rea was missing, hence this does not shake the societal conscience. Therefore society should have a sense of forgiveness towards him, and this implies he should be acquitted, right? We discussed this thing yesterday. So once the accused is acquitted, then what will happen? If the accused is acquitted, then what will happen? Will we be like just acquitting him and will give him back to the society and let him do the offenses which he was doing, and he got the defense of it as an as he proved section 84 unsoundness? Then what do you think? What will happen once the accused gets the defense of unsoundness and he is acquitted? Okay, see, the answer to this what is not given under IPC. To get the answer of what will happen to the accused once he is acquitted is given under section 3, no, it's 334 and 335 of CRPC. I hope all of you remember that the criminal trial, it the role of CRPC in criminal trial. I hope I told you in the very beginning and in the very first class of this course that CRPC plays its role at the investigation stage, mainly at the investigation stage. But in this case, we have the answer to what will happen to the accused under CRPC only. Now, what will happen to the accused, I'll tell you. Just a sec. Let me open CRPC. Yeah, I have already opened it. You guys are not having your barrack, right? I'll share it with you. Look what they are saying. judgment on of acquittal on ground of unsoundness of mind. And what is this acquittal? Acquittal is because section 84 was proved. That is, unsoundness was proved, right? So whenever any person is acquitted upon the ground that at the time at which he is alleged to have committed an offense, he was, by reason of unsoundness of mind, by reason of unsoundness of mind, incapable of knowing the nature of the act, alleged as constituting the offense, or that it was wrong or contrary to law, as it was given in section 84 also. I hope you remember it. Or contrary to law. The finding shall state specifically whether he committed the act or not, because it's a part of judgment. So the trial court must state specifically that the offense was committed by the accused or not, and he was granted the defense of uh, section 84 or not. Once he is granted the defense of section 84, then comes the stage of his being tried, being jailed, or we say conviction. But since he got the defense of section 84, then conviction should not follow, right? Now section what section 335 says is, person acquitted on such ground. Such ground here means the ground of unsoundness, which was referred to in section 334. Okay, to be detained in safe custody. That's all. That was the thing which I wanted to tell you. That's all. That he would be detained in safe custody. Now they have given the procedure and how the detention will follow. Okay, so he is not like sent to the ordinary jail. Rather, he is sent to this. He is rather detained in a lunatic asylum, or there are like other institutions as well, wherein the accused who was proved to be an unsound is kept or detained. Okay, so now mm, just a sec. Yes. Okay. So section 84 and its linkage with this section 334 and 335 is understood. Now we will move into section 85. Let's read about section 85 first. Section 85 basically talks about intoxication. Okay, intoxication, that too, it has to be involuntary intoxication. If someone consumed or got intoxicated voluntarily, then this defense is not available. The defense of section 85 is not available. Okay. Now let's give a reading of section 85 first. Yes. So section 85 says act of a person incapable of judgment by reason of intoxication caused against his will. What does that mean? It has to be against his will. Means they are clearly writing here that it has to be against his will. Means if intoxication was voluntary, then the defense of section 85 is not available. Okay. Now, again, this starts with nothing. Nothing is an offense which is done by a person who, at the time of doing it, if you compare the language of section 85 with section 84, you will find a lot of similarity here. The language is quite similar. Look, nothing is an offense which is done by a person who at the time of doing it. Here also it is written who at the time of doing it. By reason of unsoundness of mind. Here, since section 84 talks about unsound mind, so there they have written by reason of unsoundness of mind. But since section 85 talks about intoxication, so here they have written just by reason of intoxication. Rest everything remains same. Is incapable of knowing the nature of the act, incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Is either wrong or contrary to law. Now, thereafter, they have added this proviso, provided that the thing which intoxicated him was administered to him without his knowledge or against his will. They are just reiterating this fact which I told you here, that it has to be a involuntary intoxication. Then only the defense of section 85 is available. Okay. Now, let's come to section 86. Now, what section 86 tells us is it also deals with intoxication only, but it kind of creates an exception here wherein the offense require a particular intent. If the offense requires a particular intent, then this defense of intoxication will not be allowed. Okay, look, here it is written. Offense requiring a particular intent. Offense requiring a particular intent or knowledge. By intent or knowledge, what do they mean? Yesterday I explained you what are these intent or knowledge. Yes, mens rea. These are basically mens rea. MR, mens rea. Intent is higher degree of mens rea. Knowledge is somewhat lower degree of mens rea. Hence, intent is very requires a higher burden of proof. It is more difficult to prove, right? Since it is an higher degree of mens rea, so it's necessarily implies that it would be more difficult or harder to prove as compared to knowledge. Knowledge is somewhat lesser degree of mens rea and comparatively easier to prove. Okay. Now, committed by one who is intoxicated. That's all. Now, let's read the main para of section 86. In cases where an act done is not an offense, unless done with a particular intent, particular knowledge or intent, a person who does the act in a state of intoxication shall be liable to be dealt with as if he had the same knowledge as he would have if he had not been intoxicated. So they have created a exception of intoxication here, that if the offense which is committed by the accused or the offense for which the accused is being tried requires a particular kind of intent, and he committed that offense, then then even if this involuntary intoxication is proved, then also he won't be getting the defense of section 85. Okay. Here again they are again mentioning this voluntary intoxication part, which intoxicated him, what was administered to him without his knowledge or against his will. Okay. So section 86 is also done. If you guys have any question or doubts regarding that, you may ask me. Otherwise, I will move forward. Yes. Okay. Section 86 illustration. I need to think about this illustration. Offense requiring a particular intent. Okay. We will come to this at some point later. I'll tell you this illustration thing. Actually, the thing is, we need to complete this. Then we have to come to consent part also today. Okay. Okay. So let's come to section 82 now. what does section 82 tells us? It tells us act of a child under 7 years of age, which is now again it starts with nothing. Nothing is an offense which is done by a child under 7 years of age. So by the language of section 82, we can make this that they are simply stating it, nothing is an offense which is done by a child under 7 years of age. Okay, so a child under 7 years of age is completely exempted from every offense. And since they are just saying us it is an offense which is done by a child, and it is a declaratory provision. Okay, it declares that nothing should be considered as an offense which is done by a person of age below 7 years of age. It declares, and hence it is a conclusive proof, right? Have you read about section 4 of Indian Evidence Act? It tells us about three types of presumptions: may presume, shall presume, conclusive proof. So this is the presumption which is raised in section 82. Okay, simply nothing is an offense which is done by a child under 7 years of age. Now section 83. Section 83 tells us act of a child above 7 and under 12 years. This means here they are talking about a child who is above 7 years of age but less than 12 years. Okay, by a child above 7 years of age and under 12 who has not attained sufficient maturity of understanding to judge of the nature and consequence of his conduct on that occasion. Means here they are not saying that that this is a conclusive proof. It would not be a conclusive presumption. Here the court will look at the surrounding circumstances and will see whether the accused or the child who is being tried before this court for the offense, whether that offense requires requires that the if that offense requires that sufficient maturity, then only, and the child also has that mental state or that amount of maturity, only then this this defense of section 83 will not be allowed. If that child is not having that maturity, then section 83 will be allowed. Look, just look at it like this way. If maturity, then defense of section 83 not allowed. If not sufficient immaturity or the child is immature to understand the nature and consequence of his act, then section 83 defense allowed. Okay, did you get it? Okay, so we have completed section I think section 81 is left. 82 is done. 83 is done. 84, yeah, 84 is also done. 85 is done. 86 is done. Just remember this what we say, this this is a legal term, doli in capex. This is many a times asked in exams, that where is the defense of doli in capex mentioned. So it is mentioned in section 82. Remember this. Okay. Section 83 is child who is above 7 years. 84 unsoundness. 85 intoxication. 86 also intoxication, but it's kind of an exception to 85, that it will not be granted if the offense required a particular intent. Okay. So section 81 basically deals with necessity. Let's read section 81 once. Guys, I hope you are able to see these the whiteboard which I shared, right? Now we have to read section 81. Look what section 81 tells us. Act likely to cause harm but done without criminal intent and to prevent other harm. So again it starts with nothing. Nothing is an offense merely by reason of its being done with the knowledge that it is likely to cause harm. If it be done without any criminal intention, they are referring to criminal intention to cause harm, and in good faith. Good faith, section 52, for the purpose of preventing or avoiding other harm to person or property. Okay. So what section 81 tells us is, Basically, it is defense of necessity. Now, suppose I give you an example of this because it would be better to understand this with the help of an example. Suppose there is a captain of a ship. Okay, this is a ship. Now they are sailing in the ocean. Here they see a small boat. A small boat which has maybe four to five people. Okay, and there is a bridge here, like the bridge of, it's an overhead bridge, like we see in in various places that the ocean is flowing from below, and we have a bridge over here above it, and the bridge has many cars, trucks, etc. Okay, now the situation is such that if the ship continues in this path, the upper head of the ship will surely strike this bridge, and all of these, the trucks, the cars, and the other passengers on the bridge will get hurt or might die as well. Okay, then instead of going in this direction, what the captain of the ship does is he goes in this direction, and some of the passengers of the boat got seriously injured. Now at the trial, the captain of the ship says that if he had continued his path, that was this path, then this would have caused a greater harm than it has been caused by striking this ship, this boat, small boat. Okay, so this is the defense of section 81, which can be available, which can be pleaded as a defense if the person has acted in good faith. This is a very important term here. He must act in good faith because he actually prevented the bigger harm, that was the striking of the bridge, and he turned his ship towards the boat, right? Now section 81 is done, right? If anyone has any doubt regarding any of the provisions which I taught you today, kindly let me know. For the time being, let's leave section 87 till section 95. Okay, now let's start with private defense. Now in private defense, it starts with section 96 and goes on till section 106. Okay. Section 96 is basically just telling us that things done in private defense, it just tells us that things done in private defense will not be an offense. That's all. It does not define what is private defense and what do you mean by private defense. It is just a provision which says nothing is an offense which is done in exercise of right of private defense. Okay. Let me show you my barrack as well. Look, nothing is an offense which is done in the exercise of right of private defense. That's all. Nothing is an offense which is done in the exercise of right of private defense. That's all. It tells us nothing more. Then from section 97 to 106, we have various situations, or we can say actually section 97 to 106 tells us what is the complete, what we say, definition of private defense is. It tells us various situations wherein it tells us various situations of uh, various situations where private defense can be exercised. And it section, if we compare it with section 99, section 99 tells us till what extent does right to private defense exist. Extent of right of private defense is being talked about in section 99. Okay. Now let's give a direct reading of section 97. See, every person has subject to the restrictions contained in section 99 to defend. I told you na, that section 99 tells us the restrictions or the extent to which the right of private defense can be exercised. Okay. Okay. How will you know determine whether child is mature or not? Okay. Look, the maturity of child will depend upon many circumstances. Like obviously you cannot, like I told you, that mens rea is what? It's a state of mind, right? It's a state of mind. So one cannot peep into the mind of a child or a person to understand what was his state of mind at the time when he committed the offense. We cannot do so. Like you cannot like have a straw into the mind of the accused or the child to know what was the state of mind of the accused at the time when he committed the offense. For that we need to check what are the acts or the what was his conduct before and after the act in question, the act or conduct, how deliberately or how or or how, or in what details his planning was. Did he just stab once? We get into the details, like if like I give you an example. If a child is a child has, this is a child, he has killed B. Okay, this is a child and he has killed B. Now this child is of age in the bracket of 7 years. He is more than 7 years but less than 12 years. So section 80 83, yeah, section 83 will come into picture, and the prosecution will prove that he had sufficient maturity to understand that he was, what he was doing was actually wrong or contrary to law. This is the job of prosecution, right? Because the offense of killing, that is murder, is an offense against the state, right? Prosecution, that he had sufficient maturity, this will be the job of prosecution. Now to prove this, what all evidences he can produce? Evidences, one evidence can be his birth certificate. Okay, this will be, second evidence can be that he had if he killed B with the help of a maybe knife. Okay, let's suppose child killed B with the help of a knife. Now here prosecution will prove that he stabbed B with the help of knife, with the help of knife. Now, what were the number of stabs which were actually inflicted by the child on B, on the body of B? If it was only one stab, if it was around 10 stabs. What does one stab imply? One stab imply that though he maybe acted in various like there are some exceptions of section 300 as well. He may have been acted in one of those as well. But since we are here proving that he was sufficiently mature, then we will be examining the length of the stab as well, till what extent the knife penetrated into the body of B, and where did he stab, that will also be examined. If the child stabbed on the leg, then we can say that no, he did not have the intention and did not have sufficient maturity to understand that this act of his, that is stabbing on the leg of B, would result into the death of B. But if the same act would have been done by the child and he had stabbed on the body of B at the chest, maybe at near heart, so, and this stab was we say grave, or this stab aggravated or penetrated into the heart of B, then we can say that this child had the sufficient maturity to understand the nature of the act, and hence he should be convicted, and section 83 defense should not be allowed. Here section 83 defense allowed, right? Did you get it? um, Mansoor, did you get it? Let me know. Other, I'll move forward. Then I'll move forward. Okay. Thanks a lot. Okay, we got it. Now, yeah, we were talking about section 97. Okay. So section 97 Let me open the barrack for you. Yeah, every person has a has subject to the restrictions contained in section 99 to defend first his own body and the body of any other person against any offense. Remember this thing, against any offense affecting the human body. Then secondly, the property, whether movable or immovable, of himself or of any other person against any act which is an offense falling under definition of theft, robbery, mischief, criminal trespass, or which is an attempt to commit theft, robbery, mischief, or criminal trespass. Now let's break up section 97. Yeah. So section 97 talks about first body and property. Okay. So in property, they are including movable as well as immovable property. Immovable as well as movable property. In body, own as well as other. Other person. So this other person can be related to or might not be related to the person, the accused. Okay. Now let's read section 97 once again. Every person has a right subject to restrictions contained in section 99 to defend his own body and the body of any other person against any offense affecting human body. Okay. So let's suppose I'm giving an example of section 97 here. Okay. Let's suppose there is a child. Child is below 7 years. What does this mean? That the case, if the child is below 7 years, what are we talking about? Which section are we talking about? Section 82, right? So now suppose you now let's make it somewhat interesting. Let's suppose you are the person who is accused. Okay. Now what happened with you was there was a child of below 7 years of age. Okay. He was carrying a gun with him. Okay. So he was carrying a gun with him and he aimed at you. He was a fun loving child. He aimed at you and he said, uncle, should I shoot? Or ma'am, should I shoot? What would you do? Tell me. You don't have the right of private defense because section 97 tells you that nothing is an offense which is done by a person below 7 years of age. And in section 97, they are clearly writing that the right of private defense is only against an offense right? It is only against an offense. And section 84 clearly tells you that nothing is an offense which is done by a person below 7 years of age. Tell me, what will you do? Tell me. Aims gun at you. It's a loaded gun. Tell me, what can you do in such a situation? See, the answer to this lies in section 98. Okay. Now, what section 98 talks about? Section 98 tells us right of private defense against act of a person of unsound mind, etc. They are writing etc., which means it will include other defenses as well, which I told you. Look, when an act which would otherwise be a certain offense, if the defense was not taken, then it would have been an offense, is not that offense by reason of youth. Youth is section 82, 83. Okay, let me write. Youth is section 82, 83. I don't know what is happening with this. It's section 82, 83. And want of maturity of understanding, unsoundness of mind, which is section 84, right? Or the intoxication of the person doing that act. Intoxication, that is section 85 and 86. Right? Or by reason of any misconception on the part of that person. Every person has the same right of private defense against that act, which he would have if the act were that offense. Right? So, here you will have your right to private defense, and you can just give him a tight slap and snatch the gun from him. Okay? Did you get it? Are you guys following? Okay. Then we have section 99. Now, what section 99 tells us? Acts against which there is no right of private defense. Okay. There is no right of private defense against an act which does not reasonably cause the apprehension of death or of grievous hurt. Death, section 300, grievous hurt, section 321. or section 320, section 320 rather, it's section 320. If done or attempted to be done by a public servant acted in good faith under color of his office, though that act may not be strictly justifiable by law. Okay. Then second para, there is no right of private defense against an act which does not reasonably cause the apprehension of death or grievous hurt if done or attempted to be done by the direction of a public servant, by the direction of a public servant acting in good faith under color of his office. Again, though that direction may not be strictly justifiable by law. Then there is no right of private defense in cases in which there is time to have recourse to the protection of public authorities. Okay, so these are basically provisions which related to public officers. Now, extent to which the right may be exercised. Look, what section 99 tells us is that the right of private defense is basically a defense. Okay, it cannot be used to punish. You cannot use the defense of private defense to punish. Let me give you an example here. Suppose there was this A and this B. He was carrying a gun with him and he aimed at B. Okay, he aimed at B. Now B, he had read law. He knows that he had a right to private defense. He tried to contact police. Police said that yes, we will be there by in 15 minutes. But in 15 minutes, the A would have shot upon B and B would have been killed. So what B does is he thrashed A, thrashed him. Thrashed him means he actually gave him some punches and all and took the gun away from him, snatched the gun. Now the gun is with B. Now B has the gun and A is lying there. Okay. Now what happens is when A hears the police sirens, what A does is A starts to run away. On this, what B does is he picks up the gun and shoots A in order to prevent him from running. Section 99 tells us that this thing is not allowed. Here, the defense of section, or we say he won't be, B would not be allowed to take the defense of private defense, that he was acting in private defense, because the transaction wherein he was under a threat of being murdered or killed ended here when he thrashed A and he was now in possession of gun. Thereafter, he should have left the case to be or should have waited for the police to arrive. He cannot use this defense in order to get A punished or in order to punish A. he cannot use this right, this right which is available to him as a private defense as a means to punish someone. Okay, so private defense is a defense and is cannot be used to punish. Keep this in mind. Private defense is a defense always, not punishment. Okay, now section 100. Look, what section 100 tells us is it tells us the various situations wherein the defense of private defense extends to causing of death. Okay, but section 100 only talks about when the harm is to body. When the and in section 97, in section 97, what did we just now read? Body, property. Okay, but section 100 only talks about when the right of private defense is available to the extent of causing the death of the aggressor, or the, like, defense is obviously at the time of aggressor only, not the accused. He is the aggressor, causing the death of the aggressor. It tells us various situations wherein wherein the defense, wherein the private defense extends to causing the death of the aggressor. And for body, we have section 103. It tells us various situations wherein the right of private defense extends to causing of death of the aggressor. Okay. Now let's read section 100 once. Yeah. Section 100. When the right of private defense of body, they mentioned clearly, it is body. Okay. Extends to causing death. Extends to causing death. The right of private defense of body extends under the restrictions mentioned in the last preceding section to voluntary causing death of or any other harm to the assailant. Assailant here refers to aggressor. Okay. If the offense which occasions the right, exercise of right of any of the descriptions herein after enumerated. So now they tells us what are the situations wherein the right of private defense extends to causing the death of the assailant or the aggressor. These are the 6 situations. Okay. So it basically are like basically relates to, like, wherein uh, the the person is under an apprehension that death may be caused. Then we have uh, another one wherein the grievous hurt may be caused. Yeah, this is the second one wherein grievous hurt will be caused. Then here, just look at thirdly, fourthly, and fifthly and sixthly. Just look at them. They have mentioned an assault with the intention of committing rape. Okay. Then fourthly, assault with the intention of gratifying unnatural lust. Fifthly, assault with the intention of kidnapping or abducting. Sixthly, an assault with the intention of wrongfully confining a person. Please tell me what is the difference between first, second, and what the remaining clause, the four clauses. What's the difference between these two? Tell me, what's the difference? Then we have this seventh also, an act of throwing or administering asset. This was inserted by 2013 amendment. Okay. This was inserted by amendment of 2013, Criminal Amendment Act 2013. Remember this. They have asked this thing also many times in exams. Okay. An act of throwing or administering acid or an attempt to throw or administer acid which may reasonably cause apprehension that grievous hurt will otherwise be the consequence of such act. Now tell me, what's the difference between this firstly, secondly, and third, fourth, fifth, and sixth and seventhly? What's the difference between these? First and secondly are somewhat in somewhat uses a different mens rea. Okay, first and second talks about reasonable apprehension, right? So here the burden of proof will be much less as compared to the burden of proof in situations of third, fourth, fifth, sixth. In seventh again, they have used the term reasonably cause apprehension. So it will also be included here. Okay. Here they have used the term intention, which is a higher degree of mens rea and difficult to prove. Got it? Are you guys following? Let me know if you are not. Okay. Now let's come to section 101. It just talks about when such right here refers to right of private defense extends to causing any harm other than death. Okay. If the offense be not of any of the descriptions enumerated in the it's a like clear, very clear and simple section. Just a plain reading of this section will suffice. If the offense be not of any of the descriptions enumerated in the last preceding sections, the preceding section being firstly, secondly, thirdly, fourthly, fifthly, sixthly, seventhly, the right of private defense of body does not extend to voluntary causing of death to the assailant, the aggressor, but does extend under the restrictions mentioned in 99 to the voluntary causing to the assailant any harm other than death. Okay, so these are the situations where death may be caused, and apart from these situations which are mentioned in section 100, apart from these situations, that is the 7 situations mentioned in section 100, in all other cases, if death is caused, then the defense of private defense will not be available. Got it? You may cause any other harm, but that should not be caused. This is what is mentioned in section 101. Okay. Now we have this section 102, commencement and continuance of the right of private defense of the body. Look, what happens is, like I took the example wherein A aimed at B. Remember? Aimed at B with a gun. Okay. I told you, I discussed this example just now. Now here, when did the right of private defense started? Tell me, when did it start? It started when A pointed the gun at B. The moment he pointed the gun at B, the right of private defense of B started, and it continued till till he made the call to police and etc. Other people maybe tried to help him. It continued. When did it end? The moment B comes in possession of the gun and A is no longer in possession of the gun. It ended right there. Okay. So if B does any act after the right of private defense has ended, then he won't be getting the defense of private defense and he would be tried as any other accused. Rather, in that case, he will be himself would become the accused. Here he was the victim. Remember this thing. Here he was the victim and he would have got the right of private defense. And even if he had caused uh, caused death of B, caused death of A, even then it would have been allowed. But once B comes in possession of gun, no. When B comes in possession of gun, then right of private no. No. Please understand this, that right of private defense is available only against the aggressor. Okay. Right of private defense is available only against the aggressor. It's not that if A was the aggressor in a particular circumstance and he comes in possession of like he aims the gun at B and now B aims the gun at A, then A will not have his right to private defense here because there cannot be a right to private defense against right to private defense. Did you get it? It is only available against the aggressor. There cannot be a private defense against private defense. Remember this thing. This is also been asked various times in exam that whether now A will get the right of private defense against B. So answer is no. There has to be a limit, right? The transaction was started by A. B did not start the transaction. Since A started the transaction, so he will be the aggressor. He will not become the victim later on. Okay. Now this thing is also done. Now section 103, I discussed it earlier also. Section 103. What does section 10 talk about? 103 talk about? It talk about causing of death in exercise of right of private defense to protect property, and the property can be movable or immovable. And they have mentioned various situations wherein this right of private defense extends to causing of death when there is a reason, apprehension of in order to protect the property. And they mentioned 3 to 4 circumstances. Yeah, they mentioned 4 circumstances wherein this right of private defense extends to causing of death. Now let's give a reading of section 103 also. Look, when the right of private defense of property extends to causing death, okay, the right of private defense of property extends under the restrictions mentioned in section 99, restrictions which we have just now did, to voluntary causing of death or of any harm to the wrongdoer, if the offense, the committing of which or attempting to commit of which, they are punishing, like they are giving the defense even of attempt, not only the commission, but they are giving the defense to attempting also. Occasions the exercise of the right be in offense of any descriptions hereinafter enumerated. Now these are the 4 situations. These are robbery. Robbery is done by robbers. Okay, it is section, anyone, robbery section 390. Okay, it's section 390. Housebreaking by night. Thirdly, mischief by fire committed on any building, tent or vessel, which building, tent or vessel is used as human dwelling. Only then this will extend to causing of death. Okay, or as place of custody of property. Fourthly, theft, mischief or house trespass. By human dwelling, they basically mean a house, rather a home. Okay, and custody of property, maybe a warehouse, where the things or the uh, various things of the accused of the person has been kept. Okay. Fourthly, theft, mischief, or house trespass. Under such circumstances as may reasonably cause apprehension that death or grievous hurt will be the consequence if such right of private defense is not exercised. Okay. So this was about section 103. Now let's come to section 104. Section 104, it also does not require uh, any explanation. It just mentions about what are the situations wherein it just tells us that when death cannot be caused, when such right extends to causing any harm other than death. Okay, same as the language of section 101, same is the language of 104. If the offense, the committing of which or the attempting of committing occasions the exercise of right of private defense B. Theft, mischief, criminal trespass, not of any of the descriptions enumerated in the last preceding section. That right does not extend to the voluntary causing of death, but does extend subject to the restrictions mentioned in section 99 to the voluntary causing of the wrongdoer any harm other than death. Okay. Now section 105, again, it has the same language as of 102. Commencement and continuance of right of private defense of property. In 102, instead of property, they are written body. Okay. The right of private defense of property commences when a reasonable apprehension of danger to the property commences. That's all. The right of private defense of property against theft. Okay, they have mentioned the various situations against robbery, criminal trespass, and house breaking by night. The four situations which they mentioned in section 103. They are talking about them in context of like when the right of private defense start and end in those four particular situations. Okay. Now section 106. Right of private defense against deadly assault when there is risk of harm to innocent person. Now, what this section tells us is that if while exercising the right of private defense, the person actually causes a harm or actually causes a harm to an innocent person who was not at all involved in maybe the assault or the 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 act against which the right of private defense is available, then in that case he the person who was exercising his right of private defense may get the defense of section 106, wherein it would be much of a like it would be too much to expect from the person who is under a fear of death or imminent danger, that he would be like having a straight mind, or will be having a rather if in the words of Supreme Court, we cannot expect the person to measure his act in golden scales. We cannot expect him to weigh each and every act of him in golden scales, and then take the decision whether this act is available to him, or this defense is available to him. If he by chance or by if he doesn't it doesn't act, and that act causes the death of an innocent person, then he should be acquitted, or he should be allowed the defense of private defense. See what it says. If in the exercise of right of private defense against an assault which reasonably cause the apprehension of death, the defender be so situated that he cannot effectually exercise that right without risk of harm to an innocent person, his right of private defense extend to running of that risk. Wait, I'll explain this with the help of an example. Suppose there is A, and here we have a mob. Here there are many people. Okay. There are many people over here. All these are persons. Now, this person aims at A. He is a sniper. Okay. He aims at A. Now, A was also carrying a gun with him. what he does is he shoots in the mob. Maybe his target may hit this person, his target may hit this person, his target may hit this person as well. So this is the situation which is covered in section 106, that these are though innocent person, but if A, while exercising his right of private defense, accidentally or maybe without any intention kills any of these, then also he would be granted the right of private defense. Available. Okay. Now we are over with private defense as such. Now let's come to section, not section, rather let's come to the topic of consent. Okay. Tell me, what do you mean by consent? Tell me, what is consent? Consent, if you ask me, it is basically the option either to accept or to reject. Yes, or we can say it is the active will of the person, which is consent. Okay. Now, if consent has not been defined anywhere. Consent is not defined. But we have a somewhat discussion, or we say that section 90 basically talks about consent. It does not define consent, but it talks about consent. Okay. Now let's come to section 90. Here, consent known to be given under fear or misconception. A consent is not such a consent as is intended by any of this code. If the consent is given by a person under fear of injury or under a misconception of fact, and if the person doing the act knows or has reason to believe that the consent was given in consequence of such fear or misconception, then that would not be a valid consent. Then they mentioned consent of an insane person and consent of child, that is below 12 years of age. Anyone who can tell me what's the age of what's the age of a child according to IPC? What does what is the we say according to IPC? What's what should be the age of the person for him to be considered as a child? Can anyone tell me? Under 7 years, under 12. Okay. Look, there is somewhat confusion here. Okay, like, let me tell you one more thing. If you read section 293, which tells us about obscene materials to young person. Okay, so here they have mentioned the age of the child to be 20 years. Let's read it once. This is just out of curiosity, nothing else. Let's read section 293. Look, what does it tell us? Sale, etc. of obscene objects to a young person. Whoever sells, lets to hire, distributes, exhibits, or circulates to any person under the age of 20 years. 20 years. Any such obscene object as is referred to in the last preceding section or offers or attempts to do so shall be punished on conviction extend to 3 years, etc. So in IPC, rather, I would say in every law, this child has been given a different age. If you read the constitution, you will see section 21A, wherein it talks about right to education. There the age mentioned is 14 years. That state should offer everyone 14 years. And at some places in DPSP, they have mentioned about elementary education, and there they have mentioned age to be 12 years. Then in IPC only, in section 361, which relates to kidnapping, if the male is 18 and female 16, this is the, no, it's rather female is 18 and male is 16. Okay, so there is somewhat this thing is not clear as to what exactly is the age of a child. But in many of the provisions, for example, let's say POXO, or in many other provisions, they have considered age of child to be either 14 or 18. These are the two age which are mostly used in the legislations in India. Okay. Now let's come to section 90 again. Consent. What does it tell us? Consent is not such a consent which is given under a fair or misconception of fact. Okay, these are the two terms which they have used. The consent is not a consent which is given under a fair or misconception of fact. Now, and if the person doing the act knows or has reason to believe that the consent was given in consequence of such fear or misconception, and the person knows or reason to believe or has reason to believe. Okay, tell me if there are any doubts till now. If there are any doubts, just let me know. I'll explain this section 90 again. Don't worry about this. Rather, I have not completed it yet. Section 90 is a section 90. Yes. Yes. Okay. So, if consent is not a consent if the consent is given by a person under fear of injury or under a misconception of fact, and if the person doing the act knows or has reason to believe that the consent was given in consequence of such fear or misconception. Now, tell me one thing here. What are which the consent of whom are they talking about here? The if the consent is given by a person, what this person is, who is this person who is acting under, who is giving the consent under fear or under misconception of fact? Tell me here, what this person refers to? Yes, this person here refers to victim. He is the victim here, whereas in our previous exceptions, in general exceptions, what we did, what we had read, that the mens rea or the act was done by the accused. We were actually examining the mens rea of the accused, but here in section 90 we are actually examining the mental state or the state of mind or the mens rea of the person. Person here is our victim. Okay, but in the later part when they write, and if the person doing the act here refers to the accused, the aggressor, act knows or has reason to believe. These were the these knows or reason to believe is are one of the two circumstances or types of mens rea. What are the three types of mens rea? Intention, knowledge, reason to believe. They have not mentioned intention, they have just mentioned knowledge, reason to believe. Lower degree of mens rea, lower proof as compared to intention. Then reason to believe, lower degree of mens rea, lower degree of proof required as compared to knowledge. So they are not talking about intention here, they are just talking about knowledge or reason to believe. Okay. Here talking about victim knows or reason to believe. Here they are talking about accused. Okay. If you have any doubts, please ask me. Now let's connect this consent with section 375 and section 376. Tell me, what are 375 and 376? Tell me. Yes, they talk about rape. Here, 375, rape. A man is said to commit rape if he, these are the circumstances which constitute rape. Okay, these are the four circumstances which constitute rape. Now, under the circumstances falling under any of the following seven descriptions. First, against her will. Second, without her consent. For the time being, we are just concerned about this provision. That is, consent is not a consent. No, just a sec. Yeah, a man is said to commit rape if he does any of these acts. These are these four acts under the circumstances falling under these descriptions. Okay, so we are concerned with secondly for the time being, without her consent. Consent as defined in, not defined, rather as discussed in section 90. Okay. Now let me give you a example. Suppose there is this A and he is getting married to B. B is wife or the lady. Okay. And A is husband. Now suppose what happens is B, like earlier what used to happen was that it was actually the parents who used to decide with whom you will be marrying, right? So sometimes there were situations wherein the wife or the lady was not even aware or did not ever even see the husband or the person with whom she is getting married to. So once they got married, then suppose at after marriage there is another person C who comes to B, that is the wife, and tells her that he is the husband. And since he was the husband, thereafter they had sexual intercourse. And B consented to it because he was the husband and she did not ever see him. According to C, he was the husband. As they here, what was this? This was a misrepresentation. He was not actually the husband, rather he was some stranger, but he represented B that he is the husband. Now tell me whether this consent would be a valid consent here. Now question is whether it is rape. Tell me whether it will be considered to be rape. B consented to it, but there was a misrepresentation on the part of C, and after that they had sexual intercourse. Tell me, will it be considered to be a valid consent? B consented to the sexual intercourse, but she consented to the sexual intercourse with her husband. She did not see the face of the husband, that is another story. But she consented to have sexual intercourse with her husband and not with C. Here, there is misrepresentation on the part of C. He misrepresented to be the husband of B, that is wife. Actually, he was not the husband of B. Rather, the husband was A here. So, here it will be said to be rape. Yes, it will be rape because it was not a valid consent. And just now we read section 375. Secondly, talks about without her consent. Okay. Secondly, talked about without her consent, and section 90 tells her the definition of consent. According to section 90, since it was the consent was due to a misconception of fact, that was that C is the husband, wherein actually in reality C was not the husband. So this will not be a valid consent according to section 90. Hence, C would be convicted for rape. Tell me, have you understood? Tell me. Now, section 90, para 2. What does para 2 talk about? Talks about consent of insane person. But this insane person also include in the main paragraph they have written intoxication as well. So what is this? This is actually 84 unsoundness. What is intoxication? Intoxication is section 85 and 86. Okay. What does section 90 para 2 tells us? Yeah. Section 90 para 2 tells us about consent of insane person. If the consent is given by a person who, from the unsoundness of mind or intoxication, is unable to understand the nature and consequence of that to which he gives consent, then it will not be a valid consent. Okay. I don't think there is anything which needs to be explained here. It's simple definition that if the person is insane or unsound or intoxicated, then his consent will not be a valid consent. Okay. Now, consent of child, unless the contrary appears from the context. Contrary appears from the context. What are they talking about here? That if the section mentions about any other age, if the consent is given by a person who is under 12 years of age. So a consent given by a person who is under 12 years of age will not be a valid consent unless the section says otherwise. Unless the particular section says otherwise, then the consent of a person will not be a valid consent under if he is under 12 years of age. Okay, done. Then if anyone has any doubts, kindly let me know. Otherwise, I'll move forward. Now, let's come to section 87. Section 87 basically talks about voluntary non-fit injuria. That is, if you consented to suffer harm, then you will not be if you consented to suffer harm, then you will not be allowed to prosecute the accused or the aggressor. Act not intended. Let's give a direct reading to it. Yeah. Act not intended and not known to be likely to cause death or grievous hurt, done by consent. Nothing which is not intended to cause death or grievous hurt, and which is not known by the doer to be likely to cause death or grievous hurt, is an offense by reason of harm which it may cause or be intended by the doer to cause, or to any person above 18 years of age. They mentioned clearly the person has to be above 18 years of age who has given consent, whether express or implied, to suffer that harm, or by reason of any harm which it may be, which it may be known by the doer to be likely to cause any such person who has consented to take the risk of that harm. Okay, so suppose there is A and there is B. They decided to have a maybe fight by using swords. Now, in the fight, what happens is A got injured. A got injured. Okay. So here, since A consented to suffer harm, because when he entered or when he agreed with A to fight using swords, he basically consented. He basically consented to suffer harm. So he B would not be said to B will not be said to be committing any offense if A got hurt, because A consented to it. Okay. If you have any doubt, kindly ask me. Then we have section 88. Now, section 88 talks about a situation wherein consent was not there, but the act was done in good faith. Act was done in good faith, plus it was for benefit of the person only, the person who did not consent. Okay. Now, let's give a bare act reading to section 88. What does section 88 tells us? Act not intended to cause death, done by consent in good faith for person's benefit. Nothing which is not intended to cause death is an offense by reason of any harm which it may cause, or be intended by the doer to cause, or be known by the doer to be likely to be caused. They have used all the three kinds of mens rea here: intended, known, likely, or reason to believe. Okay. To any person for whose benefit it is done in good faith. That is very important term here. The act of the doer must be in good faith, and who has given a consent, whether express or implied, to suffer that harm or to take the risk of that harm. Okay. Section 89 is somewhat similar to section 88 only. It's just that here it mentions about the consent of the person. Here it mentions about the consent of guardian, because the person is below 12 years of age. Like in section 90, we read about child or insane person, child below 12 years of age, insane person, or intoxicated person. Okay. So we are done with section 88 and 89. I'll explain section 88 again. No worries, no worries. I'll explain it again. Just take a break of maybe 5 minutes, and thereafter we'll continue. Yes. So we are after the break. Yeah. Section 88. What does Section 88 tells us is it talks about act done in good faith, but consent is there. I think I made a mistake before the break. Consent is there for harm. But the act of the doer is done in good faith. This is very important. It has to be done in good faith. Okay. Now, suppose there was this A and there was this B. He was a surgeon. A was suffering from a disease which required a surgery. A and B are also neighbors, and B owes a enmity with A. But since A required a surgery, A consented that okay, you perform the surgery on me. But at the time of surgery, what B did was, since he owed an animosity with him, with A, he deliberately cut some important vein. A died as a result. A died. So A and B were neighbors. B was a surgeon. B owed an enmity with A, but A was suffering a disease which required a surgery. Therefore, A consented for the surgery. But B, since he owed an animosity with A, he cut some important vein. As a consequence, A died. Here, B will be convicted. Since, though he was acting with consent, but he was not acting with good faith. Good faith was absent. If by mistake B had cut some important vein, if it is proved that it was by mistake and not because of the animosity that the vein of B was cut, then B will get the defense. But it has to be proved that B was acting in good faith and it was a mistake that important vein was cut. Okay. Now, section 88 is done. Now, we have section 89. Just give me a sec. Okay. Now we have section 89. What does section 89 tell us? Section 89 tells us act done for the benefit of child or insane person. Here also they have mentioned good faith. And for the definition of good faith, you have to rely upon section 52 of Indian Penal Code. Okay. So act done in good faith for the benefit of child or insane person by or by consent of guardian. These two bys are, I don't know why they have put these two by. Just we have to just stick to benefit of child or insane person done by consent of guardian. So let's read the para now. Nothing which is done in good faith for the benefit of person under 12 years of age or of unsound mind by consent, either express or implied, of the guardian or other person having lawful charge of that person is an offense by reason of any harm which it may cause or be intended by the doer to cause or to be known by the doer to be likely to cause to that person. Okay. Provided first that this exception shall not extend to intentional causing of death, or attempting to cause death. Secondly, this exception shall not extend to doing of anything which the person doing it knows to be likely to cause death for any purpose other than the preventing of death or grievous hurt or the curing of any grievous disease or infirmity. The example which I mentioned, which I talked about in section 88, this applies here as well. Same example can aptly be fitted here as well. Okay. Thirdly, that this exception shall not extend to voluntary causing of grievous hurt or to the attempting to cause grievous hurt. Then fourthly, that this exception shall not extend to abatement of any offense, to the committing of which offense it would not extend. So basically what these provisos are, these are like section 89 is a type of general exception, right? And what these what these provisos these are basically exceptions to the general exceptions of section 89. Okay, so so we can say these are exceptions to exceptions to the exception of section 89. Okay, exceptions to the exception of section 89. Look, the illustration will make things very much clear. A, in good faith, for his child's benefit, without his child's consent, has his child cut for the stone by a surgeon, knowing it to be likely that the operation will cause the child's death. Instead of will, they should have mentioned may. If this had been the case, then this defense would not have been available. Instead of will, there should be may. This is an example of, I would say, legislative error. Okay. Knowing it to be likely that the operation may cause the child's death, but not intending to cause the child's death. If instead of may there would have been will, then they would not have mentioned this sentence. Okay. So this makes it very much clear that this will should be read as may, knowing it to be likely that the operation may cause the child's death, but not intending to cause child's death. Here, A is within the exception. in as much as his object was to cure the child. Okay, done. We are done with section 89 as well. Section 90 we had already done. Now section 91, exclusion of acts which are offenses independently of harm caused. Okay, the exceptions in section 87, 88 and 89 do not extend to acts which are offenses independently of any harm which they may cause or be intended to cause or be known to be likely to cause to the person giving the consent or on whose benefit the consent is given. Simple. Now section 92. Section 92 talks about the act was done in good faith, but the person did not consent. It was done without consent. The act was for the benefit, no doubt. It was with good faith, but the person did not consent to it. Okay. Now let's read this. Nothing is an offense by reason of any harm which it may cause to a person for whose benefit it is done in good faith. Good faith. It is very important term. Good faith. If good faith is absent, consent or no consent, person will be liable. But if good faith is there, then the person may escape the liability. Even without that person's consent, if the circumstances are such that it is impossible for that person to signify consent, what situation are they talking about here? Impossible for that person to signify consent. Maybe the person was unconscious, or he was a minor. He was maybe he couldn't, for some reason he could not communicate his consent, so it was impossible for that person to signify consent. Or if that person is incapable of giving consent, here they are talking about minority, that is below 12 years, according to section 90 para 3, consent of child, para 3, and has no guardian. Look here, the term guardian has come, or other person in lawful charge of him, from whom it is possible to obtain consent in time for the thing to be done with benefit. Okay. Again, we have these provisos. These provisos are actually exception to the exception. These provisos are basically exceptions to the exception, that is of section 92. Okay. Now provisos. These provisos are, if you compare this proviso with the proviso of section 89, these are almost same. Rather, these are same. Just here and there some changes are there, but rest everything is same. Okay. Now let's come to section 93. What does section 93 tells us? Communication made in good faith. It is basically telling us about communications which are made in good faith. No communication which is made in good faith is an offense by reason of any harm to the person to whom it is made, if it is made for the benefit of that person. Okay. Suppose a doctor tells the patient that you are going to die. So, and the person dies because of that shock which the doctor told him that you are going to die. Then the doctor is within this exception, as he is bound to tell, and he made the communication in good faith. Suppose the doctor knows that the patient is suffering from a heart disease, and if he tells him some news, it may shock him, and he may lead to a heart failure and he may die. then the communication will not be said to be in good faith. Here, the doctor will get convicted. He will be liable for murder. Okay? Because he was not acting in good faith. Now, we have section 94. Act to which a person is compelled by threats. Okay. Act to which a person is compelled by threats. Except murder. They have created an exception at the very start. Except murder and offenses against state punishable with death. What are the offenses against state? Suppose conspiracy or waging war against state, armed rebellion. These are the cases which are offenses against state. Nothing is an offense which is done by a person who is compelled to do it by threats, which at the time of doing it reasonably cause the apprehension that instant death to that person will otherwise be the consequence. Okay. Provided the person doing the act did not of his own accord or from a reasonable apprehension of harm to himself, short of instant death, place himself in the situation by which he became subject to such constraint. Explanation 1. A person who, of his own accord or by reason of a threat of being beaten, joins a gang of dacoits, knowing their character, is not entitled to get benefit of this exception. Okay. Then we have explanation 2. A person seized by a gang of dacoits and forced by threat of instant death to do a thing which is an offense by law, for example, a smith compared to. Okay, I'll give an example here. See, suppose there was a group of gangs. They were a group of dacoits. There was a gang of dacoits. Okay, there was this gang of dacoits, and they were planning to break into this house. This is the house which they were planning to get into. Okay. Now they found that there is a gate which is locked. Now on the way, they found a smith. Who is a smith? A person who can open locks, or chabi wala. In Hindi we call him. Person who makes duplicate keys. Okay. So this was the gang. They got to this smith, pointed a gun at him, and asked him to open this lock, otherwise they will shoot him. So this smith goes and opens this lock. Now this act of opening the lock in itself does not make him an offender, or does not make him uh, uh, does not make him liable to be convicted as these person, because he was acting under a fear of death and within the exception of section 94. Just a sec. Yeah, of section 94, because the because the person was compelled by threats. Okay, and he was within the explanation 1. Person who of his own accord Look, he was within the explanation 2. A person seized by gang of dacoits. Here in our example, the person was seized by gang of dacoits, right? And he was forced by threat of instant death. They were pointing a gun at his head to open the door, otherwise they will shoot him. To do a thing which is an offense by law. Opening the door without the consent of the owner. Offense by law. Okay. So here the person will get is entitled to the benefit of this exception. Did you get it? Okay. Okay. Now we have explanation 1. What does explanation 1 tell us is that if instead of these person getting to him, instead of these persons getting to this myth, what is the situation they are talking about in explanation 1 is instead of they being contacting him or they being forcing him, he voluntarily comes and tells them that yes, I can open this door. He voluntarily comes and opens this door for these dacoits to enter this house. Then according to explanation 1, this myth will not get this this myth will not get the defense of this exception. Defense will be denied to him because he out of his own sweet will got to the gang of dacoits and he actually was not under a fear of instant death. Rather, he on his own accord. Here, a person who of his own accord by reason of threat of being beaten, okay, joins a gang of dacoits knowing their character is not entitled to the benefit of this exception, okay, on the ground of his having been compelled by his associates to do anything that is an offense by law. Okay. So if he out of his own volition got to these gang of dacoits and asked them that yes, I will break open this door or I can just crack this lock, then according to explanation 1, this person, this smith will not be allowed uh, to will not be allowed to take the defense of section 94. Okay. Also in explanation 1, they have mentioned one more very important thing. Look, they have mentioned threat of being beaten. Threat of being beaten. And in explanation 2, they have mentioned by threat of instant death. Can you find out difference? Threat of being beaten. If he was having just the threat of being beaten, then he would not be allowed to take the defense of section 94. Did you get it? If the danger was only to the extent of being beaten, then section 94 not available. But if the fear was of death, they have not even mentioned hurt, they have mentioned death, so only death, then section 94 will be available. Okay. Now let's come to section 95, and that will be the last section of today. Thereafter, from tomorrow, we will be discussing culpable homicide and murder. Okay. Section 95. Act causing slight harm. Slight harm. Nothing is an offense by reason that it causes, or that it is intended to cause, or that it is known to be likely to cause. They mentioned all the three types of mens rea here. Any harm, if that harm is so slight that no person of ordinary sense and temper would complain of such harm. So they are basically talking about trifling acts. Okay. In section 95, they are talking about trifling acts. They are talking about trifling acts. And they are also talking about if the complainant is oversensitive, right? They are talking about complainant also, that no person of ordinary prudence or no persons of ordinary, what we say, what have they mentioned? They mentioned no person of ordinary sense and temper. A person having ordinary sense and temper would not complain of it. So a person of ordinary sense and temper, if would not complain of it, then ordinary sense and temper. If a person of ordinary sense and temper would not complain of it, then section 95 will come into picture and the person will get the defense. Person, what person? The person who had committed this trifling act. Act done. That is the doer. The doer will get the defense. Okay. Now, what are trifling acts and ordinary sense and temper? These are very circumstantial, and these depend upon case to case and person to person, very subjective terms. And it is for the court to decide what are trifling for one and what are not trifling for another in a particular situation. Okay, so that's all for today. So we'll meet in the next class. Thank you.